Hello, everybody. Gbenga Olatunji here. So today, still on the board of directors, we'll be looking at directors and the law. Directors and the law. Previously, we had looked at the role of the board of directors, the composition of the board of directors, the role of the chairman, chief executive officer, and non-executive directors. So today we are talking about directors and the law. So what are we going to be looking at under directors and the law? We'll be looking at the powers and the rights of the directors. The powers and the rights of directors. We'll be looking at the appointments, election, and removal of directors. How this concentrate on the legal framework and the dynamics, legal dynamics. We'll be looking at the duties and the legal obligations of the directors, like the fiduciary duty and responsibility, shares dealings by the directors, disqualification of directors, changing directors, and NOCLAR as it relates to the board of directors. NOCLAR simply means non-compliance to regulation. So if you are just joining us on this platform, say thank you for joining us. And people that have been on the platform before, you are welcome too. I'd love that everybody sign up. It's free. Click the notification button and subscribe to this channel. The subscription is absolutely free, but you need it to ensure that you are receiving alerts and notification when we release new videos, which definitely we are going to do by the grace of God. Also, people around you can easily be reached because you are in and among us, and we are building the community together. So please go and do that right away as you journey on into the board of directors and corporate governance environment. So after these lectures, we'll be discussing next the inductions of the directors, trainings of the directors, performance evaluations of the directors. It is important for us to know that performance evaluation is not limited to lower ranking managers and the like alone. Even the board should be evaluated and must, if I should use the word, must be evaluated. Their performance must be evaluated. So these are the items that we must talk about today, and we are going into it right away. So the powers and the rights of directors. It is important for us to know that even though from country to country, legal framework may differ, laws may be different, but one thing they all have in common is this: directors, corporate governance has its backbone in legality and regulatory framework. The laws may be different from nations, countries, kindred, but definitely there is a regulation that regulates these aspects of our society, the corporate environment. So the rights of the directors and the powers of directors are actually found and given to them by the law of the land, whether in the UK, in the US, Australia, Netherlands, Nigeria, name the country. The basis of the power of the directors is in the law and the regulatory framework provided by the nation. Okay, so when we are now talking about the directors, like previous studies, we have the non-executive directors, the executive directors, and the like. So we are talking about the executive directors now. They have a service contract just like any other employee. They have the service contract. Also, like the HR policy that binds the organization and their activities as directors. And this must have its foothold in the law of the land. So these service contracts give the directors the power and the right based on the law of the land on what to expect, what is expected of them also. So their right as it consists in their service contracts or what we can call appointment letter as to maybe remuneration, minimum notice for termination of office, renewal of office or reappointment and the like. And one of the critical power that the directors have and can exercise is the power to go into contract on behalf of the organization. Don't forget I said they have service contract with the organization too. But equally they can exercise the power to go into contract on behalf of the organization. And it remains binding because the power for control of the organization has been given to the board of the director, in which they equally can delegate it to other layers of management. So they can go into binding contract on behalf of the organization. And unless the veil of incorporation is lifted, is then the directors can have personal liability for the legal and binding contracts they enter on behalf of the organization. So for such to happen, then they must have violated their fiduciary duty or have allowed their personal interests to overrule and ride over their fiduciary contract that they have with the company or the organization. For the non-executive now, we've been talking about the executive director. For the non-executive directors and independent directors, they too have contracts of agreement with the organization with a fixed term. With a fixed term, unlike the executives that are direct employee of the organization and have employment letter or service contract with the organization and may not in the nearest future be terminated and the like. Non-executive directors have fixed term contracts, and best practices like in the UK, in Nigeria, usually the first term of their contracts will last 3 years. 3 years fixed term contract in which it will be renewed probably for another 3 years, and after that it is advised that another appointment should happen in which the non-executive, the NEDs, should resign and another be employed. This is to allow freshness on the board of directors, new ideas, and also to limit the threat of familiarity in which the non-executive directors are not that effective as they ought to be or they've been before. From the best practices perspective, 3 years term, first term, second term, renewable, 3 years. After that, the organization should be looking forward to appointment of new directors, especially the non-executive directors. Of course, directors, just as we just said, will be appointed. So If they could be appointed, they could be re-elected too. Then if they could be re-elected definitely and appointed, then they could be removed. They could be removed on so many bases, not because of performance. Performance can be there, but even on the best practices form of thing, so that they will not be too familiar and become ineffective in their service to the organization. So, how are the directors appointed? If there is vacancy for any reason, maybe a director resigned or by virtue of rotational tenure, that there is a vacancy. So the vacancy can be filled in which somebody is nominated. And when the person is nominated, the board could appoint the person. Of course, there should be a formal laid down principle and policy of the organization on how to appoint directors for several reasons like vacancy, resignation, rotation, and the like. So, having been appointed at the next annual general meeting, the person could stand re-election, which the shareholders must vote for. With, like in Nigeria and UK, simple majority is enough. 50% votes from the shareholders is sufficient enough to carry the appointed one to for the election for success rather. Pardon me. So the existing directors are required to stand for re-election at regular intervals. That's like a rotation. Tenure, when your tenure expires, another person takes over and the like. So that's not on the basis of maybe poor evaluation or performance. It is just rotational. And when tenure expires, another person automatically is appointed or proposed to be appointed. So when such exists, so then they could stand re-election for the next 3 years, especially if that rotation is the first term. So they could stand re-election for the next term, 3 years, after which they are considered to go out permanently. It is usual for directors who retire by rotation to stand the re-election. We've said that, and to be re-elected by a very large majority shareholder, especially if the performance of that person, the director, is a bit poor. It's possible that the shareholders will vote him or her out. Well, it could happen. When a director performs badly, it should be expected that he or she may be asked by the board or the chairman to resign. And if the chairman will not do that, at annual general meeting, the shareholders may not vote for the person's another tenure in office. Occasionally, a director may have the support of the board when the shareholder wants to get rid of him. That's a reverse of what I've been talking about. The board supports this person, but the shareholders just want the person out. So when this happen, well, like in the UK, the shareholders will call for general meeting and remove by simple majority vote the director. And even though the directors or the director in this case had been removed, he or she still has rights, legal rights, and especially for his service contracts, like the executive directors. Every obligation must be fulfilled on the part of the organization, even though the shareholders had agreed to remove him or her. So let us talk about the duties of directors. The duties of directors. Basically, two types of duty. The duty of skill and care. They have this duty of skill and care. That is why we said when directors are being appointed, their background, their knowledge, their exposure, all these are important, and they must deploy all this to the service of the organization that employed or appointed them. So the duty of skill and care and the fiduciary duty, which simply means directors are employed and assumed to work in utmost good faith and in the best interest of the organization. Basically, that is the summary of their duty to the organization. Now let us go into a bit of specific. The director's duty, they must act within the legal power that they have and possess. They must act within the legal framework. That is, they must not do something that will expose the organization into the other side of law and incur penalty. So they must be knowledgeable in business law. They must promote the success of the organization and to benefit the shareholders. They must see to the success of the organization. They must exercise their independent judgment without biases, without unnecessary undue favor and the like. They must exercise reasonable skill, care, competence, diligence. They must avoid conflict of interest. And this is key because if directors will not avoid conflict of interest, especially personal interest, the organization is going to suffer high costs in form of maintaining the corporate code of conduct or corporate governance. Is going to become expensive. They must not accept any benefits from third party. That is, they must ensure and try as much as possible to be far away from bribery and the like and anything that will influence their judgments. They should declare their interest, like in the case of UK and Nigeria, declare their interest in any contract or vendor or third party to the organization. If peradventure for any reason they have, they should be able to declare it to others that okay, see, so organization, I have interest in it, or so organization belongs to so which we have interest in, or I'm also a director or you are also a director in. So there should be full disclosure on the part of directors. Then they will leave the decision to the others to judge whether they want to allow it to fly or not. Let us talk now about the share dealing of the directors. The share dealing of the directors. So when we are talking about the share dealing of the directors, it is important for us to know, please note that it is criminal for a director to use price sensitive information in his or her favor because he or she is inside the organization and knows ahead of the public that such and such step is being taken that will influence dramatically the price on the stock exchange. So this is share dealing that we are talking about. It is a grievous offense for a director to do that. That is why many times the directors should, as much as possible, not have any share, if at all they have, that especially the non-executive or the independent are not supposed to have. But for executive, even where they have, they must not have those that are not disclosed. That is, those they must not arrange for shares to be purchased, maybe in the name of relative and the like of the organization, in which they can give information to buy or sell to their own favor. So they must not be found in that, and if at all, when they are found, it's a criminal offense because they are the hem of affairs. So it is easier for them to get first-hand information, and is most likely possible, humanly possible, to use it to their own favor. After a director has been adjudged offender of insider dealing, he or she could be disqualified from the role of a director and removed. So this is one aspect that will lead to director's disqualification. Other aspects of director's disqualification could be if a director goes bankrupt, is not able to pay his bills and the like, and had filed for bankruptcy in the nation, depending on the bankruptcy law and the like. So bankruptcy could make a director to lose his or her position too and be disqualified. If that person is suffering from mental disorder, of course, the person will not have good judgment and will not be able to hold the director's position again. If a director is guilty of criminal offense, maybe in connection with management of the company, or as we are rounding up, let us discuss the board of directors and NOCLAR, that is non-compliance with law and regulations. So when we are talking about this all over the world, it simply tries to address the confidentiality matter and confidentiality practices of a chartered accountant. So basically, NOCLAR has come to help the practitioners and relieve them of confidentiality role so that they will be able to reveal and expose non-compliances to the government precisely, because there are a lot of things that confidentiality that we sign to will not encourage us to do ordinarily. But NOCLAR is an exception to the confidentiality role of practitioners. NOCLAR is any non-compliance or act of omission or commission, could be intentional, it could be unintentional, that is committed by our clients. Please, sorry about the phone interruptions. I've tried to adjust that. So when an act of NOCLAR is committed, the professional has the right to blow the whistle as against not being able to discuss anything under confidentiality rule. NOCLAR permits the professional to disclose to government and authorities what he or she had observed in the course of his or her work with the client. So what are the things that could warrant NOCLAR to be lifted, or the veil of the organization, the veil of incorporation to be lifted, if we are to use the legal term? So in form of fraud or bribery or corruption, money laundering, especially if a professional observed that, should blow the whistle. Terrorism, financing terrorists, proceed of crime, security market trading malpractices, banking services malpractices, data protection violation, tax violations, environmental protection violations, basic and public health and safety issues could make a professional to work under NOCLAR, and remove himself or herself from being bound professionally under the confidentiality duty. So basically, NOCLAR has come to make the world around us better and professionals to do their work to the best of their ability to help the society. So, from G. James Associates, if you have not subscribed, please go and subscribe to us. Like, comment, click the notification button. We are value to life, we are value to your businesses. Next time we'll meet, we'll be discussing the induction of the directors, the trainings of the directors, performance evaluations of the board of directors.